Hello, Dr. Francisca Anene here, and you're welcome to PPL324 Law of Thought 2. I'm sure you have enjoyed our previous lessons and you have enjoyed watching the instructional videos. And beyond enjoying, I hope that you have learned something. In fact, a lot of things. So, we're going to be learning something new again in this video. We're going to be taking another important topic in Law of Thoughts. And as usual, I'm counting on you to pay attention, to take notes if you have to take part in the activities, think about what you will hear, and try and learn whatever lessons are available to be learned. Okay, so let's go. This is our sixth lesson, and in this lesson, we'll be looking at false representation of facts, also called misrepresentation of facts. They're the same thing. Some of the things you will be learning in this lesson will be how deceit is defined and how false representation of facts impacts on the thought of deceit. You will also learn what a fact is and how it may be misrepresented, and you will discuss the, the requirements of false representation of facts. So first thing, what is deceit? Deceit can be defined as a misrepresentation of fact intended to defraud another with the effect that the party suffers damage as a result. Please note the highlighted words. A misrepresentation of facts is what, is the cardinal element of deceit. If there's no misrepresentation of fact, then all the other elements really are of no importance. So there has to be a misrepresentation of fact with an intention to defraud. And then when a party suffers damage as a result of that misrepresentation, then we have deceit. That is why it is said that misrepresentation of facts is one of the cardinal elements of deceit. So not just a fact, but a misrepresentation. So the thought of deceit was created in the case of Hedley Byrne and Heller Partners, where the court was faced with a novel situation and had to decide. In that case, a company had asked their bankers to carry out a background check on a proposed customer, and the bank came up with a report, saying that the customer was the customer was also another company, was doing very well, was liquid, had enough funds and all of that. And the company relied on the report from the bank and entered into contract with this proposed customer, who within a short while later turned out to not be, economically viable as they thought. In fact, he went into liquidation and they lost a lot of money. And so when the matter went to court, the court had to decide whether, the plaintiff had suffered any damage and why how the defendant could be held liable. So the court came up with this cardinal principle that a person who makes a careless misstatement to another may be liable to that other person in negligence for the loss suffered as a result of reliance on that misstatement. So that point is the cardinal rule for the thought of deceit. So the elements of deceit. I'm sure you could have gleaned from our definition what the elements are, but let's list them. So the first is that the defendant made a misrepresentation of fact, right? And then the second element is that the defendant who made that representation knew that the representation was false, or he did not genuinely believe in the truth of the representation he made. Genuine belief will also include carelessness as to the truth or falsehood of that fact. And the third is that the defendant intended for the plaintiff to act upon the representation of fact that he made. And the fourth is that the plaintiff did act on the representation, and the result was that the defendant suffered loss or damage as a result of his the plaintiff suffered loss or damage as a result of acting on the representation made by the defendant. So if you have all five elements in existence, then the tort of deceit will be established. So now let's really, talk about misrepresentation. Before we do that, we'll take our first activity. The question you need to answer is, why is misrepresentation of fact said to be a cardinal element of deceit? Now to misrepresentation of fact. First question, what is a fact? We've been talking about representation, misrepresentation. What is a fact? A fact is defined as the existence of a tangible or intangible thing or occurrence which can be relayed to support a declaration or claim at another time. Right? It can also be a circumstance or incident related to the case that is being resolved by the court. So, where there's a difference, of course, in law between questions of fact and questions of law. In Nigeria, both questions of fact and questions of law are decided by the judge, right? In other countries, some other countries, questions of law are decided by the court or the judge, while questions of fact are decided by the jury. But we don't have a jury system. So when a fact, is misrepresented, it means that the fact has been falsely represented. So a false representation of fact is actually what misrepresentation means. Okay? The aspects of false representation of fact. The first thing you must note is that a false statement may be made by spoken or written words or by conduct. Spoken or written words is straightforward. If a word is spoken false or it's written down, then clearly, you can determine whether it's true or false. You have heard the words. However, taking it further, conduct can, a false statement may also be made by conduct. So, for instance, not speaking, but just shaking your head when you know that, the shaking of your head is interpreted as you saying no, and that shaking of your head is false. Actually, what is the correct thing would have been yes, but you intentionally shook your head. That will be a false statement made by conduct. The second element is that a statement of intention may constitute a false representation. So it's not a statement on an extant, occurrence, but of a future occurrence, where a statement is made indicating that a party intends to do something, but the party knows that he really does not want to do that thing. It can also constitute a false representation. So if you look at the case of Egington and Fitzmaurice, a company, wanted to sell debentures and said they would use the debentures to for development of the company, purchase of assets and all of that, and they knew that was not what they wanted to use it for. The court held that that would also be false representation. And then the third element, silence will not normally constitute fraud. And this element is based on the principle of caveat emptor. It is left for, a party who wants to engage in business with another to do his background checks, right? It is left for him to find out. It's not enough to rely simply on, what the other party did not say, or expect the other party to speak to him, right? He ought to find out. So in Keats and Earl of Cadogan, the issue was the regarding the sale of a car, and the fact that the seller of the car did not mention that the car was not in such good condition was not held against the seller, because the buyer ought to have done his own investigation and checked out the car before buying. Now, there's an exception to when, the condition that silence would not always result in misrepresentation. Sometimes silence will constitute a misrepresentation in specific circumstances, and that's where we are going to look at now. The first is where the fact distorts a positive representation. So, where in being silent, you are given a false impression. Okay, then it's like telling a half truth, and that's just like telling a lie. Okay, and then second, when a true representation of facts subsequently becomes untrue and the change is not spoken of. So it was true that, for instance, it was true yesterday that this car cost 2 million. However, owing to the change in maybe dollars and so on, the cost of the car has fallen to 1 million, and then the seller is quiet about it. That, of course, will be a misrepresentation. And then to the third scenario, where the statute imposes a duty of disclosure. So if you are required by law to disclose a particular fact, silence on that fact will be a misrepresentation. So if you look at, under the Code of Conduct Bureau requirements, public officers are expected to declare assets. So a public officer who keeps quiet about the assets, some of the assets he has, will be deemed to have misrepresented facts. To your second activity, I'd like you to discuss the exceptions to the rule of silence not constituting fraud. So we have come to the end of this lesson, and in this lesson we have mainly learned what we mean by deceit, the elements of deceit, the locus classicus for deceit, and the connection between misrepresentation of fact and deceit. We have also learned the aspects of misrepresentation of facts and exception to the rule on silence. If you have any question on what you have learned, you can post it on the discussion forum and we'll talk about it. Until our next lesson, take care.